Hello, everybody.
Good morning. Barnes County District Court is now in session this April 25, 2025. The time is now 10:41 a.m. My name is Nick Thornton. I'm a District Court Judge for the Southeast Judicial District, which includes Barnes County. We are conducting today's hearing by reliable electronic means. I am working remotely. This matter is venued in Barnes County. Court can see by reliable electronic means. The Barnes County large courtroom is connected. The door is unlocked and open. The building is unlocked and open. We are live streaming today's event on the Southeast Judicial District's live stream YouTube channel. As such, any member of the public or media can attend these proceedings in person in the courtroom or by following along on the live stream YouTube channel. The first matter, or the only matter on the court's morning docket this morning, is State of North Dakota versus Wade William Clinton, file 02-2025 CR 122. Present at the Barnes County Correctional Center by reliable electronic means. Defendant Wade William Clinton. Present for the state in the Barnes County large courtroom, Attorney Trent Jackson. Sir, were you present in court when your rights were read to you?
Yes, sir.
Can you please speak up? I'm having a hard time hearing you.
Yes, sir.
All right. So you were present when your rights were read?
Yep.
And do you understand your rights, sir?
Yep.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. You have the right to hire a lawyer. You have the right to apply for a public defender, and if you financially qualify for one, the court would appoint one for you, or you can choose to represent yourself. How would you like to proceed with respect to your right to counsel, sir?
I'll just plead out today.
Say that again.
I'll just plead out today.
That's not possible on a felony, sir.
On a felony? How is it a felony?
Well, you're charged with 2 Class B felonies. We're going to talk about the nature of those offenses in just a minute.
Two Class B felonies?
Now,
How's that?
so
I don't understand.
we're going to get to it, sir, but first things first, I need to know what your thoughts are on how you want to proceed.
What Class B felonies am I being charged with?
Possession of a controlled substance in a correctional facility, namely marijuana. Possession of a controlled substance in a correctional facility, namely buprenorphine.
What the fuck is that?
Sir, you're in court.
I'm sorry, but I don't understand this. Like, I'm not pleading guilty to that crap.
Well, I'm not asking you to right now, sir. Right now, I'm asking you, do you want to hire a lawyer? Do you want to apply for a public defender? Do you want to represent yourself? That's the question before you right now.
Yeah, I don't understand any of this. I don't. So like, this is just pointless. I need to be in a psychiatric ward is where I need to be, not in a freaking jail. I've been telling you guys this every single time. I need help with my psychiatric. I'm sorry for my language, but I'm sick of this. I need psychiatric help. I'm done with this. I'm
Mr.
done.
Clinton.
No, I'm no longer gonna go through with this. I'm done. I'm done. See, have a good day, sir.
Sit down right now.
I'm good. See ya.
Sit down right now.
No, I'm done. I'm done. I need psychiatric help, you guys. I need it. I'm done with this crap.
The court, based on applications in file, give me a second here.
I hear voices. I'm done with this. I'm done with it. Every single time. Nobody ever gets me the help I need. State hospital is where I need to be at. I gave the marijuana to the freaking cop before I got
Stop
here.
talking. Based on the recent application and file 20-2024 CR 45, the court finds the defendant indigent and will appoint a public defender at this point. That public defender, sir, is not present at this time. So, sir, I have a couple of options for you. I'd like to explain the nature of the charges, the maximum and minimum possible penalties to you, to address the potential for restitution, the potential for adverse immigration consequences, and the potential for collateral consequences with you. The court also would like to set your bail, and in fact, I'm required to set your bail within 48 hours of your arrest on this matter. Are you comfortable doing that at this time without counsel, sir, knowing that it is subject to bail review?
No, I'm not comfortable with any of this. I should be at the psychiatric ward like I've been trying to get to forever. I just tried killing myself freaking 3 weeks ago with fentanyl. I shot up a whole freaking cap full of the crap. Trying to die. I'm trying to leave. I don't want to be here no more. I want to be in fucking either get my psychiatric help or else I'm done. I'm not doing this. I refuse to fucking answer any questions. I refuse to freaking do anything. I'm not testifying. I refuse to testify. I'm done. That's my right. I refuse to testify.
At this point, the court finds that the defendant's non-participation is frustrating its intent in moving forward with the initial appearance. The court notes that in other files, there have been fitness to proceed examinations that have happened. I do not know the results of those fitness to proceed examinations. I would note, however, that at least as of September 20, 2024, there is an entry in the record in file 2024 CR 45, and the description of the letter, I can't read the substance of the letter, but the description says NDSH non-participation letter, which indicates to me, seems like the defendant refused to participate with the state hospital when a fitness to proceed examination was ordered, which complicates matters because Mr. Clinton is saying that he has psychiatric issues and needs to be addressed, needs his mental health addressed. It seems as though Judge Hovey ordered the exact type of examination necessary to get him that kind of help, and he refused to participate in that process. Nevertheless, the defendant is presumed to be fit under the statute. The court notes that I am appointing counsel to assist Mr. Clinton in his matter. I am going to advise Mr. Clinton of the charges against him and the penalties. Because it's a felony, the court is not going to take a plea of any kind, and the court will set bail, at least initially, because it is a Friday, and I want Mr. Clinton to have the opportunity to post bail before the weekend, and I wouldn't be able to set bail within the 48-hour requirement of Riverside, Belinsky, and Gerstein versus Pugh unless I do it right now. So, sir, it sounds like you might not have a copy of the charging document in this case. Is that correct?
Yeah, I'm not signing anything on that crap. I already told him that.
Sir, I'm not asking you if you're going to sign for it. I'm just saying, I'm asking you, do you have a copy of it?
Yep. I'm sorry that I'm such an asshole right now.
Well, sir, I'm not trying to upset you. I'm just simply trying to do my portion of the job to make sure you understand what's going on. At this point, I know nothing about the case. I don't prejudge the case. I'm simply trying to make sure you understand what your rights are, what you're charged with, the potential consequences for what you're charged with, and I'm required to set your bail, and I'd like to do that today. Do you understand?
Yeah.
All right. So, sir, is your name correctly spelled on that document in the upper left-hand corner?
Yeah.
All right, sir. In that document, the Barnes County State's Attorney charges in count 1 that on or about April 24, 2025 in Barnes County, North Dakota, the defendant, Wade William Clinton, did commit the offense of possessing a controlled substance in a correctional facility in violation of North Dakota Century Code section 12-44.1-21 subsection 4 and 12.1-32-01 subsection 3. By then and there, the defendant willfully and unlawfully possessed a controlled substance in a correctional facility. In particular, the state alleges the defendant willfully possessed marijuana in the Barnes County Correctional Center. That offense is a Class B felony. Count 2, the state alleges that on or about April 24, 2025 in Barnes County, North Dakota, the defendant, Wade William Clinton, did commit the offense of possessing a controlled substance in a correctional facility in violation of North Dakota Century Code section 12-44.1-21 subsection 4 and 12.1-32-01 subsection 3. By then and there, the defendant willfully and unlawfully possessed a controlled substance in a correctional facility. In particular, defendant willfully possessed buprenorphine, buprenorphine, in the Barnes County Correctional Facility. This offense, as alleged, is a Class B felony against the peace and dignity of the state of North Dakota, dated this 25th day of April 2025. State's witnesses, Deputy Danielle M. Bjorley, Griggs County Sheriff's Office, Correctional Officer Joshua Bitts, Barnes County Correctional Center, and Sergeant Nathan Morton, Barnes County Sheriff's Office. Signed, Tanya Duffy, Barnes County State's Attorney, 234th Street Northwest, room 304, Valley City, North Dakota, 58072, phone number, fax number, email address, penalty sections. Both of these counts, sir, are Class B felonies as alleged. Class B felonies carry with it a maximum possible penalty of 10 years in prison, a fine of up to $20,000, or both. The state has alleged that both offenses carry with them a minimum mandatory penalty that you submit a DNA sample for inclusion in law enforcement databases. There is also a requirement that you submit fingerprinting for inclusion in law enforcement databases. There are no other applicable minimum mandatory penalties. If you are convicted of this offense, the state legislature requires this court to impose certain court fees for a Class B felony. Those court fees include a $650 criminal administrative fee, a $100 facility improvement fee, a $25 victim witness fee, and depending on whether or not an application for public defense services is filed, $35 to apply for a public defender. Those fees may be reduced, modified, or waived under certain circumstances. If your conduct caused any loss or financial harm to another person, the court can order restitution. If you are not a United States citizen, these types of offenses carry with them significant adverse immigration consequences. They might also carry with them significant adverse collateral consequences for which the court is not required to explain. Sir, do you understand the nature of the charges? I'm not asking if you agree with the charges, but do you understand the charges and penalties?
No.
All right. The court notes the defendant has said no. The court believes that the defendant is aware of the nature and circumstances of the charged offenses. He might disagree with them, and that's fine. The court believes Mr. Clinton is aware of the penalties, especially in light of his discussion previously about seeking services at the state hospital rather than jail. I think the defendant is well aware of the charges and penalties.
I'm not aware of them because I wasn't caught with this stuff on me. I got searched. When I got searched, this stuff was not found on me. This is all of a sudden after I'm
Sir,
put in jail cell. This is the loop coming
sir,
after.
I don't want you to talk about the offense because I don't want you to say something that can be used against you and hurt your case. So I understand that you might have a defense. I understand that you might disagree with the charges. That's not the point or the questions that I'm asking. It's simply, do you understand what the state is alleging? Not whether you agree with it, not whether you have the legal defense, because you very well might. All right. All I'm asking you is whether you understand what I just read to you.
I don't understand it.
All right. And the court makes a factual finding to the contrary of that. So the next issue that we need to address, sir, because these are felony level charges, I'm not going to take any plea of any kind. Your next court hearing will be a preliminary hearing. The preliminary hearing is a threshold probable cause hearing to determine whether probable cause exists that a crime was committed and probable cause exists that you committed it. If you either waive that hearing or have a contested preliminary hearing and the court finds probable cause, your case will be bound over for an arraignment. If the court does not find probable cause at a contested hearing, then your case would be dismissed.
Good.
The arraignment, if the court either finds probable cause or you waive your right to a preliminary hearing, the arraignment would happen right after that. And at that time, the court would ask you whether you plead guilty or not guilty. But for this stage, at this time, I'm not going to ask you for a plea of guilty or not guilty. So that's what's going to happen next. That date is March 20, 2025 at 1 p.m. in the Barnes County Courthouse. March 20, 2025, 1 p.m. in the Barnes County Courthouse. Sir, do you understand when you need to be back in court?
You said what, March 20th? That's the whole year from now.
I'm sorry. I'm saying March and I meant May. It's May 20. So in about 25 days.
It's my little girl's birthday. I'm freaking out. That's cool.
So I meant May 20. The preliminary hearing is May 20, 2025 at 1 p.m. in the Barnes County Courthouse, and you'll get written notice of that date as well. But May 20. Do you understand that?
Okay.
I didn't hear you, sir.
I said okay.
All right. So the next issue I have to address, Mr. Clinton, is bail. So I'm going to hear from Mr. Jackson. He's going to give me a bail recommendation. And then I'll give you an opportunity to tell me what you want about bail, but I would again ask that you not talk about the facts and circumstances of the offense, because I don't want you to say something that can be used against you. Okay? Mr. Jackson, go ahead.
Your Honor, the state is requesting bail be set at $10,000 cash, or in the alternative, $20,000 corporate surety. The state is also requesting provisions 1, 2, 5, 6, 7, 9A, 10, 11, 14, 15, and 16 be checked. The reason for 16, Your Honor, is it appears that in North Dakota case 20-2022-CR-30, that there is an Appendix A, which seems to indicate that the defendant is currently on probation. The other reasons for the state's request is that the defendant has had previous failures to appear in 2010 case ending in 52, as well as the 2022 case that was just referenced to the court. One of those, the 2010 case, was a failure to appear for a change of plea in sentencing. And Your Honor, given what has been said here on the record by the defendant, the state is also concerned with his safety. The state is also concerned with his demeanor and the fact that he tried to walk away and got up and in fact did so until he eventually sat back down, about his appearance in court for future proceedings. The state would put forth that the state believes that the evidence against the defendant in this case is strong, as these items were found by correctional center staff and or sheriff's department officers to be within the defendant's possession. Thank you, Your Honor.
Mr. Clinton, do you have thoughts about what I should do for bail?
Every time my bail gets set at $10,000 and nobody's ever able to bail me out. I don't have anybody to bail me out at $10,000. And so like, that's just gonna be impossible. You might as well put it at $1 million, because it's never gonna happen. I'll never get bail. That's just basically saying that I have no bail. It's the same thing. So that's like giving me no, because my family isn't rich by any freaking means. $10,000 is like a whole freaking half a year's worth of freaking income for them. So there's no way I'll ever be able to freaking make bail at $10,000 ever.
So what are you asking that I do to make sure that you show up when you're supposed to show up?
I'll show up to freaking court. The only last time I freaking wasn't showing up for court was the freaking time that when I had child support one night, and then they sent bench warrants out for my arrest. I was in Wapton. This time when my freaking PO put me out as absconding, I was still in Hope, North Dakota, at the address that I was supposed to be at. I was at my address when he put out a warrant for my absconding, and I wasn't absconding by any freaking means. When the cops showed up yesterday to where I was at, I walked right up to the road waving my hand saying, "Hey, I'm right here." I wasn't trying to abscond or run from anybody. I got no place to go. I got no license. I got no freaking way of getting anywhere. I walk everywhere. So I'm not running by any means. If you can make
Yes,
it
sir.
10 of that, that would be great. That'd at least give me a freaking chance.
The number you're asking for is 10% of 10,000.
Yeah. That's a little bit better than freaking, because I'll never be able to make 10,000. Nobody's got
All
that
right.
money in my circle.
Anything else you want to tell me before I set your bail, sir?
And they never caught me with anything in my possession. I was in my freaking cell when all of a sudden they come through the door with all this crap in their hands.
I understand.
So that's 110% fact right there. Didn't catch me with nothing, none of that crap.
I understand. Anything else you want to tell me?
And I'll even take a piss test right now to prove that whatever that freaking stuff you said with the bees is, I guarantee I have none of that in my freaking system, not whatsoever. And the marijuana, I gave it to the dead.
Stop. I don't want you to talk about the facts, okay? Again, I just don't want you to end up hurting your case, okay? So I understand that you're saying that stuff wasn't in my possession. I don't know what it is.
And there's even
I
videos.
understand that to be your argument. Okay. Anything else you want to tell me?
Just that, yeah, if you gave me a lower bail, that'd be give me a much better chance, and then I could possibly get myself into treatment, before I freaking have to face all these freaking new charges all of a sudden. Every time I come in here, there's new charges always. I'm never gonna get out of jail. I got missing out on my kids' lives already the way it is. Fucking done with this life.
All right. The courts considered the constitutional provisions concerning bail. The courts considered Rule 46 of the North Dakota Rules of Criminal Procedure governing pretrial release. The court finds the following conditions of release are necessary and not overly restrictive to ensure the defendant's appearance. While I certainly understand Mr. Jackson's concerns, the court's order is as follows. Bail will be set at $1,500 cash, or in the alternative, $5,000 corporate surety at the defendant's option. So he can either post $1,500 in cash or get a bail bondsman to post a $5,000 corporate surety to secure his release. Under either option, defendant is required to follow the additional conditions as I'm going to set forth here. 1, you shall not violate the laws of any city, county, state, or nation. 2, you shall not leave the state of North Dakota without the express advanced permission of the court. 3, you must maintain appropriate contact with your defense lawyer. Because I have appointed you a public defender, that contact must be at least weekly. 4, within 24 hours of any change, you must notify the court of any change of address, employment, or phone number. 5, you shall not possess or consume any alcohol or controlled substances except as authorized by a licensed physician. You must undergo reasonable medical or other examination or testing to determine your compliance with this requirement. Next, before release, you must sign a waiver of extradition and promise to appear. You must not possess a firearm, destructive device, or other dangerous weapon. You must appear for all scheduled court hearings and appearances unless excused by the court or by the filing of a proper waiver of appearance filed by your attorney. Your next court date, again, sir, is that preliminary hearing and arraignment, which is scheduled for May 20, not March, but May 20, 2025 at 1 p.m. in the Barnes County Courthouse. You must fill out an application for court-appointed counsel before release. You must comply with all terms and conditions of probation. You must meet with your probation officer within 72 hours of your release. And you must have at least minimum weekly contact with your probation officer. You must submit fingerprinting and DNA for inclusion in law enforcement databases before release. These conditions the court expressly find are those that are necessary to ensure the defendant's appearance. The court notes that in light of the previous failures to appear in other matters, the court has sufficient cause to rebut and overcome the presumption of release on one's recognizance. I understand the state's concern here. I understand there's a difference of opinion as to whether or not the defendant was in possession of these items, considering he was in custody at the time that the items were found. It is not the type of case where a defendant smuggles inside the inmate portion of the jail a controlled substance after work release, for instance. This is a case in which defendant was brought to jail and taken into custody on other matters. And after he entered the jail, items were allegedly discovered that would constitute criminal contraband. There is a legitimate question as to whether or not those items are possessed, either actually or constructively, by Mr. Clinton inside the jail.
Yes, thank you.
So stop talking. This is where I'm talking.
Thank you.
There might not be a legitimate question as to whether or not Mr. Clinton willfully possessed those items outside of the jail, but Mr. Clinton's belongings were taken to jail with him. And so at some point, those might be a legitimate issue as to whether or not he possessed those items or whether law enforcement placed those items inside the jail for him, which triggers the enhanced offense of possessing items inside the jail. Nevertheless, the court can consider the nature and circumstances of the offense and the strength of the state's evidence. Here, the court finds that the strength of the evidence, there's no reason to disbelieve law enforcement found what they thought they found. There is a legitimate question about whether or not that was inside a correctional facility and that he willfully possessed them at the time. So that's what I'm going to say about the strength of the case and the evidence. Nevertheless, the court found initial probable cause for purposes of Gerstein versus Pugh and signed a probable cause order sufficient to hold today's hearing. The court finds these conditions specifically authorized or related to Mr. Clinton's appearance, and the court finds that all of those conditions are necessary. The court also finds that if those conditions were not ordered, there is a greater likelihood Mr. Clinton would not appear on May 20 for his next court date. Any questions, Mr. Jackson?
No, Your Honor, thank you.
Any questions, Mr. Clinton?
No.
All right. So, sir, I know you've requested and indicated that you have some mental health concerns and you would like to be evaluated. I'm not ordering that at this time. I want you to meet with your attorney because I've appointed a public defender for you, sir. I want that attorney to talk with you, and if your attorney feels it's appropriate, your attorney can file a motion with the court and we can get you evaluated. You understand that, sir?
Every time I get evaluated, yes, I understand that, but every time I get evaluated, it's the same thing. Like I need to be inside the facility in order for them to evaluate me. You understand? Like on that type of note, like they need to be able to see me in a less stressful freaking environment to where they can get a proper assessment done on me instead of just assessing me from far away where they ain't even got eyes on me.
Yeah.
You know?
So
See my behavior, my moves.
my personal view is I tend to agree that these evaluations should be done in person. The evaluators say that telehealth is appropriate and telehealth is just as good. I think that's sort of a mixed bag type question, but your attorney can request that that be done in person with a transport order. That's something to talk with your attorney about. Okay, sir?
Good.
All right. And just for the record, I don't know if the state hospital is any less of a stressful environment than jail. In some respects, maybe it is. Some respects, maybe it isn't. That's yet to be seen. If that motion is filed, we'll take it up then. But for now, that's my bail order. You got to post either $1,500 or come up with a bail bondsman in the amount of $5,000. Follow those other conditions and continue to follow the probation conditions, sir. Meet with your probation officer and we'll go from there. All right?
Thank you.
All right. With that, we are adjourned. Have a good day.
Thank you, Your Honor.
Be safe, be well, sleep sweet, and much love.